Hi, and welcome to this video presentation of the use of force within the context of international law. My name is Ahmed, and this presentation was a group effort by Hir Azim and Nazir Mubin. First and foremost, we look into what is force in legal terms. A legal definition of force shall be that force equals unlawful violence or lawful compulsion. Force entry is an expression falling under the category of unlawful violence. Enforce or force sales would be the examples of expression in the category of lawful compulsion. So, how about the use of force? There isn't a definitive answer to this. However, the use of force in realms of international law abiding to the general rule would be considered as prohibited under the United Nations Charter in Article 2, Clause 4, which expressed the following: all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purpose of the United Nations. Furthermore, the existence of the non-intervention rule composed by famed Swiss legal philosopher Emmerich de Vattel sets a principle of international law that restricts the ability of outside nations to interfere with the internal affairs of another nation, which solidify the words of the prior provision. So, are there any exceptions to this general rule of law? Yes, like in most rules and laws that exist. In terms of use of force, the exceptions that are enshrined in the UN Charter are the provisions on self-defense in Article 51 and the provisions that allow collective action by NATO against other states as enshrined in Article 42 in Chapter 4. And there is as well another exception, which is the case of humanitarian crisis. One state can, however, controversially intervene another. On exception number one, which is as enshrined in Article 42 of the United Nations Charter, the following is expressed in the provision: should the Security Council consider that measures provided for in Article 41 would be inadequate or have proved to be inadequate, it may take such action by air, sea, or land forces as may be necessary to maintain or restore international peace and security. Such actions may include demonstrations, blockade, and other operations by air, sea, or land forces of members of the United Nations. Article 41, by the way, is the law that requires states to apply non-forceful measures. The following law itself is self-explanatory. The UN Security Council will take matters into their own hands if they decided that forceful measures are necessary in dealing with the threat imposed. Next, we look at exception number 2. The second exception to the general rule is that in the case of self-defense, a state shall by the virtue of Article 51 be able to apply the use of force in order to negate the threats that they are facing. Article 51 in the UN Charter expresses that nothing in the present charter shall impair the inherent right of an individual